Guess what day it is, kids? It's High Court Judgment Day. If you are an IP nerd like me, your LinkedIn feed would have lit up today, the 11th of March 2026, with fellow IP nerds posting about this case. So, here's my recap of Taylor versus Killer Queen LLC 2026 HCA 5. Hello, and welcome back to Elise Explains IP, the podcast where we unpack intellectual property issues so business owners and advisors can understand what really matters. Today we're talking about a huge case that's attracted a huge amount of attention over the last few years, and the High Court of Australia has finally delivered its decision. As mentioned, the case is Taylor and Killer Queen 2026 HCA 5. If those names don't sound familiar, the dispute is better known as the Katy Perry trademark case. On one side is Katy, i.e. Taylor, an Australian fashion designer who registered the trademark Katy Perry for clothing. On the other side is Katy, T.Y. Perry, the global pop star, whose companies sell merchandise, including clothing, under the name Katy Perry. The dispute has been running through the courts for years, and the outcomes at each stage have been dramatically different. But the High Court has now stepped in and maybe clarified the law. This decision turns on something that is fundamental in trademark law, but often misunderstood: timing. More specifically, what matters is the position at the trademark's priority date. So today we'll walk through the background to the dispute, what the lower courts decided, what the High Court has now clarified, and what this means for businesses choosing and protecting brands. Let's start with the facts. An Australian fashion designer named Katy Taylor created a clothing label using her birth name Katy Perry, Katy, K-A-T-I-E. In 2008, she applied to register Katy Perry as a trademark in Australia for clothing. That trademark was successfully registered. Around the same time, an American singer, Katherine Hudson, was becoming internationally famous under her stage name, Katy Perry, K-A-T-Y. Her career took off in around 2008 with major international success. Over time, merchandise bearing the Katy Perry name, the singer, including clothing, was sold in Australia. Eventually, the Australian designer brought infringement proceedings. Her argument was relatively straightforward. She owned a registered trademark for clothing, and the singer's companies were selling clothing under a name that was deceptively similar to her registered trademark. So she alleged trademark infringement. But the singer's companies responded with a different argument. They said that the Katy Perry trademark should never have been registered at all. In particular, they relied on provisions of the Trademarks Act that allow for a trademark to be cancelled or removed from the register if its use would have been likely to deceive or cause confusion because of an earlier reputation. And that's where this case becomes legally interesting. At the first stage, before a single judge of the federal court, the designer won. The court held that the Katy Perry trademark was valid, and the singer's companies had infringed the trademark when selling merchandise in Australia. But the story didn't end there. The singer's companies appealed to the full federal court, and the full court took a very different view. They found that Katy Perry had already developed a sufficient enough reputation in Australia before the designer's trademark was registered. Because of that reputation, the court held that the Katy Perry trademark should actually be cancelled. Gone, boom. So instead of infringement, the outcome became the opposite. The designer's trademark was to be removed from the register, and that decision dramatically shifted the case. It raised a very important question about how reputation interacts with trademark registration. But of course the case doesn't end there, because the designer appealed again, this time to the High Court of Australia, being Australia's highest appellate jurisdiction. The High Court approached the case by focusing on a central principle in trademark law. When assessing whether a trademark should have been registered, the key question is the position at the priority date of the trademark application. In this case, that date was in September 2008. The issue was whether, at that time, the reputation of Katy Perry was already so strong in Australia that using Katy Perry for clothing would have been likely to deceive or cause confusion, or whether Katy Perry had filed for a trademark in good faith. The High Court ultimately held that the respondents, the singers' companies, had not proven the point. In other words, they failed to establish that, in 2008, the singer's reputation in Australia was sufficient to make the designer's mark deceptive or confusing in relation to clothing. They also failed to demonstrate that Katy Perry, the singer, had sold any clothing in Australia with her name on it at that time. And that finding was critical, because once that argument failed, the legal basis for cancelling the trademark fell away. Katy Perry had acted in good faith when she filed her name, and it shouldn't be allowed to reverse that decision because of later reputation. So the High Court therefore allowed Taylor's appeal and rejected the cancellation of the trademark. They also rejected a related argument that circumstances at the time of the rectification application in 2019 justified cancelling the mark. So the High Court has restored the designer's position on the validity of the trademark. And importantly, the decision reinforces that trademark validity cannot really be judged with hindsight. What matters is the commercial reality at the time the mark was applied for, not for what happened years later when somebody became globally famous. The decision highlights something that is absolutely fundamental in trademark law. Timing matters. Katy Perry's trademark registration couldn't be undone because the trademark was later to be invalid. Trademark rights are assessed at the situation at the priority date of the application. Later developments, even dramatic ones with global fame, can't necessarily undo those rights. Trademark disputes are often decided based on historical evidence about reputation, branding, and market presence at a specific point in time. That can include media coverage, sales, advertising, and public recognition. So, when businesses are building brands, the timing of the trademark filings can be critically important. And despite the celebrity angle, this case actually illustrates several practical lessons for business owners. 1. File trademarks early. The earlier a trademark is filed, the earlier the priority date is locked in, and that priority date can become incredibly important years later if a dispute arises. 2. Reputation must be proven with evidence. Simply being well known is not enough. A party relying on reputation to challenge a trademark must provide clear evidence of that reputation at the relevant time. 3. Trademark rights are not assessed with hindsight. Courts are careful not to let later fame or success rewrite the legal position that existed when a trademark was filed. The right of a person to register a brand at a particular point in time, they adopt their brand in good faith, can't be undone just because it later proves to be complicated for somebody who's famous. 4. Brand disputes can last a long time. This dispute has run for years, and multiple appeals eventually reaching the High Court. And that's not the end of it, because the High Court has sent it back to the full federal court to decide on issues 5, 6, 7 and 8 that they didn't decide on because they erred previously in their decision. So that's a reminder that brand strategy is not just about marketing, it's also about legal risk management. The long-running Katy Perry trademark battle has finally reached its conclusion in Australia's highest court, we hope. And the High Court's message is quite clear. When assessing whether a trademark should exist or continue to exist, the law focuses on what the world looked like at the time that the mark was filed. Did the person apply for the brand in good faith at the time when they made their application? Not what happened later. For businesses, that reinforces a simple but powerful strategy. Choose your brand carefully and register it early, because those early steps can shape the outcome of disputes many, many years down the track. Thanks for listening to Elise Explains IP. If you found this episode helpful, feel free to share it with someone building a global brand or launching a business. And I'll see you next time. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.